Bueno, bueno, o menos.
Day of the hearing in respect of the Westland Mineral Sands Mananui sand mining application. Just want to cover off some housekeeping matters if I can. First of all, just to outline the panel's process after the last adjournment. We spent approximately 4 hours on site on Friday afternoon, walking through the remnant vegetation, including areas of hydrology and water and the eastern escarpment and scenic reserve, which was informative, and we were accompanied by Mr. Ross and Ms. Mackay from WMS for that site visit. And that gave us a good appreciation of the overall site, the vexed issues of ecology and the proposed location of the processing plant. And then on Sunday, early in the morning, we travelled by helicopter to Westport Airport and did a flyover of the WMS site at 9 Mile Beach or Okari, and then took a site visit, which I think both commissioners found extraordinary, all commissioners found extraordinarily helpful in terms of understanding the in situ sand mine, and observed various parts of the operation. I had a particular eye to edge effects in light of Mr. Cromie's concerns around dust, albeit that this is a slightly different operation, and the reformation of the site. So those were the main features. Fortunately, it was good flying conditions, and so that was worked out really well. Today I have an appointment. I'm not quite sure what time it's going to happen, so at some point I'll just simply squiz out, and I just need a recharge of some antibiotics, so I'm just going to pop out my app which connects to my doctor, we've received some further information from Rachel. We've received an addendum, and Rachel Clark from CRC, and an addendum draft conditions. We also received from Mr. Nguyen from the council an RFI letter from Ms. Mackay and some attachment plans. So I think that's all that we've received by way of further information through email. I'm happy to stand corrected on that. And
I think there was also an email from Patini Naitahu around a condition of consent that we've been provided by Tim. I'm not sure.
I'm sure I've seen that.
Yeah.
What time did that come through, Tim?
That might have been last week.
Oh, I see. Yes, I see an email with that. Thank you. Right. So that's in the system as well. So that's the material we received. So first up, we have Suzanne Hills submitting online. So welcome, Suzanne.
Yes, Morena, can you hear me okay?
Yes, thank you. It's excellent quality.
Thank you. Shall I start?
Yes, please. We have your submission. You can speak to that and anything else you want to add.
Yeah, sure. Yeah, so in my submission, I think I made about 10 points, but today I'm really just going to hone in on 2 of them, which is the functional need and the carbon emissions.
Right.
So I want to start with the National Environmental Standard for Freshwater, the 45D regulation, and my position again is that there is no functional need to operate within 100 metres of natural inland wetlands. So I understand that the applicant is seeking 10-metre setbacks from the adjacent wetlands and the wetlands within the property.
Yeah.
So again, like the Tiga case, it appears to me that this is an operational need, not a functional need to operate within 100 metres. And as we know, those two terms are very clearly defined. And I find it really stark, the difference between the Dr. Duran's report that when he was a reporting officer for West Coast Regional Council, compared to the report, who was it? I can't remember her name. But anyway, there was only one. So Dr. Durand had a comprehensive analysis of functional need. It was in his paragraphs 161 to 165, and it included a series of tests to determine functional need. Yet for this hearing, the reporting officer simply stated in paragraph 147 that I am satisfied that there is a functional need for the activity in this location because the minerals can only be found in this location and therefore need to be mined in this location. Well, that seems incredibly superficial and lacks any depth of analysis, especially when you compare it with Dr. Duran's analysis. And the officer also relied on the Commissioner's decision from the Tiga hearing. And I would like to point out that decision, the Tiga decision, was appealed by Coast Road Resilience Group, and after mediation, the setbacks from wetlands were increased from 20 metres and also with additional riparian planting. So in the Tiga case, there was not a functional need to mine as close as 20 metres, otherwise Tiga would not have agreed to greater setbacks. It was an operational need or a profitability need to mine as close as 20 metres. But of course, during mediation, the Coast Road Resilience Group did not achieve 100-metre wetland setbacks. And I just want to explain why Coast Road Resilience Group decided not to take functional need to court hearing, and that was for various reasons. And the reason I'd like to explain this is because I think they're relevant for this resource consent application. So why didn't Coast Road Resilience Group take 45D to court and fight for 100-metre setbacks and no functional need? Well, the main reason was there was a gross imbalance of financial resources compared to Tiga. Coast Road Resilience Group are a very small community group based with funding from donations. And if Coast Road Resilience Group had had resources even slightly closer to those of Tiga, they certainly would have proceeded to court. It was also because there was a possibility that Tiga's well-funded experts could demonstrate in court that the water management system would have no change in hydrological function or change in the wetland level, which is a precondition for section 45D6 to apply. And also because Tiga had committed to a precautionary approach of starting the mining panels at the furthest point from the wetlands and applying adaptive management of the water management system, thereby possibly demonstrating that there would be no change in hydrological function or change in the wetland level. The other reason we didn't take it to court is we knew there was a high likelihood of Tiga being a scheduled fast-track project in the Fast Track Approvals Act, which they now are. And Coast Road Resilience Group saw the need to hold on to its limited funds to oppose this much larger fast-track project. And finally, the last reason was that the sensitive coastal lagoons with that Tiga application were deemed to be within the coastal marine area and outside the definition of natural inland wetlands. And that only left the natural inland wetlands on the northern boundary that could be protected by section 45D. So I'm just making all these points to demonstrate that the Tiga resource consent does not set a precedent of mineral sand mining with 100 metres of wetlands meeting functional need. I believe this resource consent should be examined against the same rigorous set of questions that Dr. Duran set out in the Tiga hearing, And I note that Dr. Durang continued to uphold that there was no functional need throughout the hearing process for TIGA. And additionally, this government has recently released its proposals to dismantle the National Policy Statement for Freshwater and National Environmental Standard for Freshwater. And these include the addition of operational need in section 45D. So this indicates to me that this government sees a risk to mining development from a court determination of functional need in section 45D. And I mean, I just encourage the panel to refer back to Dr. Durang's S42A report, his paragraphs 161 to 165, which set out a detailed analysis of whether functional need would be met. So that's all I have to say on functional need. No, I have one other thing to say. For the TIGA consent, it was deemed that there was a functional need to mine within 100 metres. But now we have a scheduled on the TIGA project on the Fast Track Act, and that Fast Track project is about 10 times the area that was consented with this RMA resource consent. So clearly, there was no functional need to mine with 100 metres at that site because there's an area 10 times that resource consent site which TIGA are looking to mine. So I just state it again, there is no functional need to mine within 100 metres for this resource consent. The other, I'm just flicking through my other points because I'm in amidst of the war on nature by this government, and I just haven't been able to keep up with everything that's going on here. But the only other further comment I would like to make is my point 9, which is that the application lacks an emission report, and this critical lack of information means the proposal cannot be measured against the climate change provisions of the RMA Amendment Act 2020 and the Climate Change Response to Zero Carbon Act. And this proposal is contrary to the imperative of rapid decarbonisation and transition to a low emission economy. And as we know, carbon emissions are now considered an environmental effect under the RMA. But for this resource consent, there's no information on the level of emissions, no analysis of how they could be reduced or eliminated, and no profit offsetting. And I continue to fail to understand how the ETS can be considered the main mechanism for carbon emission mitigation when it has failed to rapidly reduce Aotearoa's gross emissions. And I seek that the panel take the view that additional mitigation of the operation's carbon emissions, i.e. beyond the ETS, is reasonable and necessary. And such mitigation could be native tree plantings in the region or investment in pest and browser control to help keep native forests as healthy carbon sinks. And it would be reasonable that this should be at a level that mitigates at least 50% of their emissions. So it's clear that it's an environmental effect under the RMA, so surely it requires, like any other effect, to be avoided, remedied, mitigated, and if this is not possible, offset or compensated, so that low or zero emission activity is incentivised. So this new emission-intensive economic activity needs to be held account on their emissions. And it just seems to me and many other people on this planet that inaction on climate while the Earth heads towards 1.5 degrees warming like a freight train is negligent and a non-option. So here is the opportunity for the panel to lead the way and act courageously to do the right thing by our climate and also by our precious wetlands. Thank you, that's all I have to say.
Thank you.
No, it's very clear.
Yeah. Kia ora, Ms Hills, Mark Geddes here. Given that functional need is listed under regulation 45D for extraction of minerals. Have you given any thought of what a functional need would be for a mine?
Well, I think it's covered by Dr. Duran's analysis. I mean, it's like a functional need is like there is no other option. It has to be in that location, whether it's the actual mining or the ancillary activities associated with that. And clearly it is not only possible in that location. I mean, that regulation is there to protect wetlands. It's a protective measure for wetlands. It's basically saying you can only mine within 100 metres of wetlands if that's the only possible option you've got. I mean, that's like it's saying that for infrastructure, isn't it? I don't know if it's like the transmission lines. If there was some massive wetland and there was just a geological impossibility that those transmission lines could go around that wetland, then there'd be a functional need to put those transmission lines across that wetland.
Thank you. There's no further questions from me.
Just trying to understand, is the function, just to remind me again, Dr. Durand referred to 45D, is that engaged when you come within 100 metres of a wetland, is it?
That's right, yes. It says if there's no functional need, consent cannot be granted within 100 metres of mining of a wetland.
Even if you apply the hydrology, the hierarchy of effects?
That's right, even if you apply the hierarchy of effects, but there's a precondition that there has to be a change in the water level or likely to be a hydrological connection change in function. There's a precondition for that. But then there's something else. It's confusing and it's changed, hasn't it? They changed it recently, that 45D. There's also something about earthworks. So it depends on the type of activity. I mean, it needs to be looked at in more detail and it needs to be analysed against Dr. Duran's excellent set of questions and tests for functional need.
All right,
and what the reporting officer has done is just flippant.
So do you know how it's changed since the Tika hearing?
Oh, well, they removed the coal mining part, didn't they? And then they fiddled around with it was a complicated thing anyway. You had to read it about 10 times before you understood it. So some of those set preconditions have changed.
Yeah, because I understood the applicant to say, for example, there were parts where on the eastern boundary they were within the 100-metre setback, but they weren't changing the hydrology and therefore did not trigger the rule, which suggests to me that the precondition for that 100-metre rule to apply is a type of effect that means the wetland is potentially affected through the alteration of the hydrology.
That's right. So, I mean, like mining within 10 metres is not going to affect the hydrology of the wetland, says the applicant. I mean, that's a pretty difficult thing to prove. And as we saw with the Tiga case, there's a lot of uncertainty associated with that. And that's where they took that precautionary approach, where they were not going to start the mining panels anywhere near the wetlands. They were going to start the furthest point away from the wetlands to demonstrate their very complicated water management system would not have an impact on the wetlands. And here we've got a resource consent which is seeking to mine up to 10 metres from a wetland. And from what I can see, they want to start at the wetlands, not at the furthest point from it. So
They've changed their configuration to do a first run in year one on the southern and western boundaries.
well, that's good.
Not the eastern boundary.
Well, that's good.
That's in response to Ngāi Tahu or Putini Ngāi Tahu's concern about the impacts on Te Wharewhare and Lake Mahaniapua.
Right, that's good. I think if you look at that 45D, it says something like likely to change, or it's got that sort of wording. So, you know, this is all modelling that they're doing, aren't they, through this, you know, water modelling system. You know, it's dependent on the inputs. It depends on how the model's set up. It's not a certainty that they won't affect the water level or the hydrological function of the wetlands.
I don't think it's entirely a model, because what happens is they do the geological assessments, they do the piezometer tests, then they do a run through the sand to see whether the behaviour is as expected, and then they come closer to a wetland with a high level of confidence that if the geology shows a perched wetland, for example, it's not going to be hydrologically connected to the substrate they're mining. So it's a combination. It's because you don't have data. It's intrinsically an inductive process, but it's an inductive process based on biophysical factors.
Yeah, sure. There's real data that's inputted into the model.
Yeah.
I understand that. There's still no absolute certainty around it. And the basic fundamental comes down to protecting our precious wetlands. And 10 metres seems incredibly close to a wetland.
Can I just clarify with the applicant something about that, because I wasn't quite sure. Mr. Ross paced out 10 metres from the scenic reserve wetland. Is the mining going to occur within the 10 metres or beyond it?
Beyond it, beyond boundary.
Yeah.
Boundary.
So it's not within 10 metres, it's beyond.
Sorry, that was a mistake, my error, not within 10 metres, but only a 10-metre setback.
All right. No, that's helpful. Let's clarify that for me. Thank you. Thank you, Ms. Hills.
Okay, thank you.
All right. So now we go to Karen Stewart.
She pulling out.
Pulling out.
I don't wish to be
Okay.
This will dismiss.
Right. So now on to council officers. And Rachel, do you want to kick off?
Certainly. I have provided an addendum to my reports. In basic parameters, I don't really change too much about what I've recommended in my 42A report at this point. A couple of points that I just wanted to clarify with the commissioners. In particular, the Environmental Initiative Trust had quite a bit of discussion around the definition of a river, whether the drains on site were a river or drains. It was my position on the 42A report. I still stick with that they are actually drains. There are clear in the 1980s when you retro lens aerial photographs, you can see that the drains were actually cut through the dune system at that point, and the definition in our land plan clearly says that drains that are being made aren't considered rivers, so I think it's pretty clear that they are drains and not part of the river system. Although in some sections of it, they certainly have naturalised over the years, and that's quite a common thing on many dairy farms and various places around the coast. When you go have a look on site, see fish and eels and things in the drains on the farms, but they still are clearly drains, but they do have some things living within them. In terms of wetlands, which is the other big issue that we have come across. Mr. Payne, who's the ecologist who reviewed this, has provided me a few points to go through, and is actually here in the room with us.
Yeah.
He has some more information to present to you for the Westland District Council, which finds combined these evidence there. So I'll go through what I've got here, and then I'll leave it in your hands if you'd like to ask him questions now, or wait till he's presented the Westland District Council information and address those questions.
Yeah. So there's additional material that we're likely to hear. Is it not logical then to go to Mr. Payne first? Because both of you will want to address in light of that evidence rather than after it.
Can I just ask a question before Payne arrives? So, Ms. Clark, you're saying the definitions of the land and water plan or the regional plan don't apply to these rivers or drains. Does the NPS on freshwater management still apply, because that applies to all freshwater, not regardless of whether it's a river or a drain?
I believe that it doesn't apply because it's not a natural, it's a man-made thing that doesn't have any particular values.
So if you look, if I looked under the NPS freshwater, somewhere in there would say that it doesn't apply to man-made rivers, or sorry, man-made drains.
I'm not sure if it makes that specific. I'll have to go back and check myself.
What are the permitted activities for a drain?
Sorry?
What are the permitted activities for a drain?
We have no particular rules that apply to drains, so essentially divert a drain, block a drain. Like to do with the drain, our particular rules don't have anything that restricts anything to do with drainage.
So regardless,
Apart from the becoming flooding issues on your neighbours.
Yeah. So other than the usual restriction on increasing the degree of flooding on adjacent properties, essentially the council would give WMS a compliance certificate for cleaning out all of those drains. All right, Mr. Payne, welcome.
Sarah Bowden, legal counsel have requested they present their submissions prior to Mr. Payne.
Oh, okay.
That's acceptable.
Yes, subject to my requirement to pop out, that sounds fine. So who are we hearing from, and are they ready now?
Good morning, Commissioners. My name is Beth Butler-Ford. I'm here remotely from Auckland, where we're experiencing some Westland weather nonetheless. And I'm here with Katia Fraser with some brief legal submissions in support of the 42A report. These have been circulated electronically since housekeeping this morning, so only really in the last half an hour. So I'm aware that you probably don't have electronic copies before you of
Well, let's just-
these legal submissions or of the other supplementary statements from the council's other experts.
Oh, okay, so
We're in your hands as to whether or not you would want to take a brief adjournment to have a look at those before we present, or if you're happy for us to go ahead and then have the physical copies for your records.
how extensive is this material?
Our submissions are brief, and they really just cover the 4 legal issues that we have that have come up during the course of the applicant's case. The information from the experts and Ms. McGrath are more extensive than that. So might take a little longer to review.
Right.
If you're wanting to consider them before you hear from those experts.
Yeah, I suspect probably it's best if we do read the material before, because then we've read it, and then the witness has spoken to it. And by that stage, we will have been able to grasp its dimensions a bit easier.
Yes.
So I think that's probably the best way to go ahead. So I've just got a email from Mr. Nguyen from the council, who's helping with the administration.
Mm-hmm.
And so it looks like there are 6 documents.
Yes, I think that's correct. Yes.
Okay, so that's a bit to work through. So why don't we adjourn to consider that? And that ties in well with my requirements. So we'll let you know when we return, but it's expected to take at least probably half an hour for us to get through that material. Does that sound all right?
That sounds perfectly reasonable. Thank you, sir.
All right. So thank you for navigating that. So we'll go through that now. Thank you.
Thank you.
Yeah.
For that, we'll now return to Ms. Butler-Ford.
Thank you, sir. If you're happy for me to just run through our submissions before we can then pass on to our experts, I can get underway with that right now. So
Thank you.
these submissions are made in support of the report prepared under Section 42 of the Resource Management Act, and they address the very limited legal matters that have been raised during the course of the hearing. In our view, there are 4 such matters. There's the activity status of the proposed activity under the operative district plan, which includes both interpretation of rules and questions as to bundling. There's the application of Section 86.3 to the Pounamu overlay rules within the SASM chapter of the proposed plan. There's questions around the appropriateness of a permitted baseline, and then there are questions of the significance of the forest fragments that the applicant is seeking to remove and their status under the NPSIB. So our submissions will be very much limited to those 4 matters, and matters of expert opinion will be left to the relevant authors and experts that you have there with you today for the Section 42A team.
Thank you.
So the first point that we have there relates to the activity status of the proposal, and the first element of this relates to the interpretation of rules that apply to the proposed activity. As was covered on the first day of the hearing, Ms. McGrath has having considered the operational evidence of Tim Chase, has concluded that the wet compressor plant is in fact falls within the definition of mining within the operative Westland District Plan, and therefore its breach of the discretionary standards is not relevant because those standards don't apply to mining. But Ms. McGrath does continue to be of the view that there are other buildings within the proposed plant area that contain a range of activities that fall outside the definition of mining, although they might be part of a mine's wider operation. Specifically, testing laboratories and workshops for heavy machinery do not fall in her view within the definition of mining as it's related to the extraction and winning of materials from their natural state and land. More appropriately, they fall within the definition of industrial activity in that they relate to the testing of materials and the repair of vehicles. We note that there are no specific rules for industrial activities within the rural zone under the Westland District Plan, and as such, these are discretionary activities under Rule 5.6.2.2c, the second bullet point of that rule, where they meet discretionary standards set out in Table 5.7. Where they do not meet those standards, they would fall to be assessed as a non-complying activity. Ms. McGrath does not accept that the distinction between the mining and industrial buildings is unworkable. Simply put, if the building is directly involved or an integral part of the extraction or winning of minerals from their natural state and land, then they fall within the definition of mining. And if they are part of wider mine operations in connection to that mining, then they are not part of mining and would most likely fall to be industrial activities. It's not unusual for a proposal to have related but at times quite distinct activities being undertaken on a single site, with different activity statuses applying to differently defined activities. What is key in assessing the application, in this application or any application, is how each activity undertaken on the site is defined, because different activities have different effects. Such an assessment should not be unworkable for the applicant, provided that the effects are managed, which on their assessment they can be. It is submitted that the applicant's interpretation of the definition of mining reads words into that definition that are not there as it appears in the plan, and that the definition of mining is clear and unambiguous, if narrower than you might expect in other plans. It might be helpful to consider that definition is really expressed, for want of a better term, it's expressed as a verb. So it's talking about the actual winning and extraction rather than the mine as an overall operation. So it's a relatively narrow definition of mining in the operative plan. It's accepted that given the change of position about the status of the wet compressor plant, which was the one piece of built form on the site that did not meet discretionary standards, it's accepted that the industrial activities on the site now do all meet discretionary standards, and therefore can be considered as a discretionary activity rather than a non-complying one. Moving on then to the definition of Indigenous vegetation clearance, which is subject to its own rules under the operative Westland District Plan. So Ms. McGrath.
Just to be clear, the laboratory component meets the standards and therefore is a discretionary activity?
Yes, that's correct.
Can I ask a question?
Yeah, sure.
So, you're saying the workshop doesn't meet the definition of mining, is that correct?
Yes.
So if I was a miner and my pick broke, that would fall, if I repaired that pick, that would fall into the category of an industrial activity?
I think that our understanding of the machinery workshop was that it was a repair workshop for larger machinery and more akin to a mechanics workshop rather than those more minor repairs of sort of handheld material, handheld equipment. But that is just based on our understanding of the description in the AEE.
Is it not the same though that, you know, the pick is just a way of extracting materials, and same with the digger or whatever other equipment is just a means of extracting materials. So therefore, the process of mining invariably includes fixing plant and equipment.
And I think, look, I'll step in there. And I think, though, we need to be very careful that we don't read into the definition of mining more than what it says. And it might be that it is normal to have facilities that are there to ensure that anything that's used in mining can be fixed. Doesn't mean that it should be included in the definition of mining. Because those activities might actually have effects on the environment that are quite different to the actual extraction of the mineral. So the council is very aware that it needs to look at effects, and the effects of a workshop, in its view, can be quite different from the effects that's covered by the definition of mining.
Well, the mining discretion enables you to address the effects. So there's quite a large number of matters of discretion. Why would we read a definition with an entirely effects lens when the purpose of the definition is to create a activity categorization that enables the assessment of those precise effects?
I don't think we're saying that you read a definition with an effects lens. What we're saying is the activities have been defined separately because there are different effects from each activity. So the council in its district plan wanted to ensure that mining, the actual act of mining a mineral, is covered by the definition of mining, and anything that's outside of that is covered by industrial activities. And as you've said, Commissioner, it is true that the matters of discretion within the rule of mining are really so extensive that in our view, they're really a discretionary activity, as opposed to a true RD, which would have a lot less matters of discretion. It is a slightly unusual plan in that way, and plans certainly are drafted slightly differently these days. But look, if the council has further information as to exactly what would happen in that repair shop, that information I don't think is sufficient at this stage for the council to agree that those aspects of the application fall within the mining activity as defined in the plan.
Yeah, I guess I'm struggling to understand why the naturally incidental features of running a mine should be excluded from the definition of mining. There'll be repair shops and methods of metallurgy and testing to examine the extent to which you've adequately extracted the minerals. What planning purpose do you say gives reason for us to read the definition as excluding those ancillary activities?
I don't know whether we would necessarily call them ancillary activities. The council considers those activities in their own right. And the council was not provided any information as to whether the mine as it is defined, mining as it is defined in the district plan could still take place without those other activities that are also being undertaken on the site.
Yeah, I'm not sure that. So what do you say a laboratory or a workshop associated with the mine, the plan intends to define as a different planning unit to be managed separate from mining and addressed as a separate activity?
That's right, that's what we do say. And I am aware of other mines where all that happens at the site is the mining, and then workshops and things like that are on a different site. So everybody, mines differently, but there are certainly mines that are restricted to the mining activity itself. And it could be that the other aspects are a kilometre away, 10 kilometres away, but they're not always undertaken on the same site as the actual mining of the mineral. At the end of the day, though, in our view, it actually is of no significance because the matters of discretion are so broad that you're going to have to consider, you have to assess basically every single effect. And the council's interpretation of Indigenous vegetation clearance pushes the activity into a discretionary status.
Right. Okay, no, it's that's clear, thank you.
Thank you.
I'll pick up on the written submissions again at paragraph 2.8. So Ms McGrath considers that the Indigenous vegetation clearance required to remove the forest fragment areas prior to mining falls outside the definition of mining and requires a discretionary activity consent under Rule 5.6.2.2c, the third bullet point of that rule. Mr. Lowe's statement of evidence of the 19th of May accepted this interpretation, but during that hearing we understand that he has reconsidered this view and returned to his original application that vegetation clearance fell within the definition of mining. We understand that this interpretation of the relationship between the discretionary vegetation clearance rule and the restricted discretionary mining activity rule turns on the fact that Indigenous vegetation clearance is not expressly excluded from the mining rule. This is in contrast to the fact that vegetation clearance under the third bullet point of 5.6.2.2 is expressly excluded from permitted activities set out in Rule 5.6.2.2a. both the first bullet point of that rule and then the third standard at the end of that rule. As we understand it, Mr. Lowe takes this to mean that Indigenous vegetation clearance must be included in the restricted discretionary mining activity rule and therefore does not need a separate consent under the discretionary rule. This is not accepted. Given that mining is clearly defined, it is not appropriate to refer to other rules in an attempt to broaden that definition to include additional activities. We submit that there is no reference to 5.6.2.2c being the vegetation clearance rule in the mining rule, because that rule only applies to mining as defined in the plan, and we submit that that definition is not so broad as to include Indigenous vegetation clearance, where that's subject to its own separate rule. On the other hand, we submit that permitted forestry under Rule A could include elements of Indigenous vegetation clearance as part of, for example, forest management. And so the relationship between the two rules is clarified by, is assisted and clarified by the express exclusion. Again, as submitted above, it's not unusual for a proposal to have separate and distinct activities with different statuses within the same proposed activity, wider activity. It has also been suggested that the fact that matters of discretion in the mining rule relates to adverse effects on significant Indigenous biodiversity, that this means that the vegetation clearance is necessarily included within the scope of that rule. It would be unusual to expand a definition of an activity which is clear and unambiguous by reference to matters of restricted discretion. It is submitted that there is reference to the Indigenous vegetation in the matters of restricted discretion because mining may well have adverse effects on significant Indigenous vegetation, even when that vegetation is not cleared. These are the effects that the matters of restricted discretion are concerned with, and in addition, we note that there is no matter of restricted discretion that specifically relates to the clearance of Indigenous vegetation. If the applicants, we note that if, by way of example, that if the applicant's interpretation of the relationship between these rules was to be found correct, that a site that is 100% covered in Indigenous vegetation could be cleared in preparation for restricted discretionary mining as a restricted discretionary activity. However, if it was to be cleared for permitted agriculture, that would default to discretionary overall. This would not be an outcome that we consider would be consistent with the overall structure of the Westland District Plan. It's therefore submitted that a discretionary consent is required for the Indigenous vegetation clearance proposed as part of the wider application. And for completeness, we do not understand that the applicant has suggested that that consent's not required under the proposed plan's Indigenous vegetation clearance rule in Rule Eco 5. So that is Council's. That is our submission in terms of the relationship between the vegetation clearance and mining rules. If there are any questions.
So what you're saying in relation to your last point is that regardless of the activity status under the operative district plan, consent's required under the TTP for Indigenous vegetation clearance, and the applicant accepts that. Is that what you're saying?
Yes, that's our understanding of their position.
So it's not contested.
Right. In terms of overall, the last point in terms of our first, the first legal issue being the overall activity status, we just noticed that there were questions on the first day of the hearing about how the panel should approach matters of restricted discretion that relate to mining if the most stringent activity status is in fact discretionary, as we submit that it is. This is effectively a question of bundling. in our view. So if the vegetation clearance, mining and related industrial activities on site overlap to such an extent that they cannot reasonably be assessed separately, then the proposal as a whole would of course be subject to the most stringent activity status being discretionary. And effectively the matters of restricted discretion would give way to the council's the panel's unrestricted discretion under that full discretionary activity status. We've just got at 2.21 just the three matters that the South Park decision considers are relevant when considering whether or not to bundle activity statuses and apply the most stringent activity status. These are whether or not one of the consents is controlled or is restricted discretionary activity, and that the scope of the discretion is relatively restricted, and that the effects of the exercise of the two consents would not overlap to have consequential and flow-on effects. We would submit that the first criteria may be met, but that the second two are not. In particular, as noted already, the matters of restricted discretion that apply to mining are really quite broad for a restricted discretionary activity in its traditional sense, and that there are few matters that would fall outside those matters of restricted discretion. They include such broad matters as amenity values and other broad categories of restricted discretion, and that as we understand the applicant's operational evidence, the Indigenous vegetation clearance and industrial activities have a very strong overlap with the restricted discretionary mining activity, such that it would be artificial to separate them. So with that in mind, we're of the view that the matter should be considered as a discretionary activity overall, rather than the panel's discretion being restricted to the matters set out in Rule D. Moving now to the third point, which relates to the immediate legal effect of SASM Rule 7, which related to the Pounamu overlay. It's acknowledged that that rule hasn't been identified as having immediate legal effect in the proposed plan, and that while it might be arguable that Pounamu is a physical resource that contributes to the understanding and appreciation of New Zealand's history and culture, we accept, Ms. McGrath accepts that the matter was considered, the precise argument was considered very recently in the Barrytown decision, and that in that case it was found that the rule did not have immediate legal effect. It's therefore accepted that the rule, that Rule 7 of the SASM chapter does not have immediate legal effect, and therefore consent is not currently required under it. Moving now to the permitted baseline. The applicant has sought to have a permitted baseline applied to the consideration of this application. The panel may, and 4.2 simply sets out the wording of the provision that gives the panel the discretion to apply a permitted baseline. In particular, we note that it relates to an activity, a permitted activity, the effects of a permitted activity, rather than simply meeting a list of permitted standards. So while a permitted baseline activity does not have to be the same type as the proposed activity, the application of a baseline is less likely to be appropriate if the proposed activity does not share common characteristics with those permitted activities. And it's also less likely to be appropriate if it is not considered to be in keeping with objectives and policies of the plan, of the relevant plan. Listed at 4.4 are a number of considerations that decision makers have had their attention directed to in the Littleton Harbour case about how to essentially matters to consider when determining whether or not to exercise their discretion to apply a permitted baseline. At 4 points, which I won't read out for you, but they are listed there essentially from that case. The permitted baseline requires the provision of a non-fanciful example of a permitted activity with measured effects so that a meaningful comparison can be made, as opposed to a smorgasbording or cherry picking of effects of permitted activities out of context. It's important that the activities as proposed, that the baseline activities are proposed in sufficient detail to withstand scrutiny. In other words, a permitted baseline is not simply a list of standards that apply to a range of permitted activities. This approach would run the risk of creating unreal comparisons for the purposes of effects. With no specific permitted activity example, we note that there is no specific permitted activity example set out in the applicant's evidence. But as we understand it, they appear to be referring to a permitted baseline of an agricultural activity, which is covered by the permitted rules of the operative plan. Excuse me. So Ms. McGrath's 42A report and the addendum that she'll shortly present to the panel identifies that effects associated with permitted agricultural activities and she has applied a permitted baseline of an agricultural activity and has discounted the effects of it for the reasons set out in her addendum report. However, she notes that there are a number of ways in which the proposal differs from what you might reasonably expect from a permitted activity. For example, Ms. McGrath considers that it would be fanciful for an agricultural activity to operate 24 hours a day, 7 days a week, and it would there would be realistic limits on the extent of built form for an agricultural activity, even though there isn't a specific standard for building coverage under the permitted rules. There is a real world limit on the extent to which you would have building coverage associated with a permitted agricultural activity. This is part of these considerations need to be part of a permitted baseline assessment, even though there are no permitted standards that limit hours of operation or building coverage. In summary, it is submitted that the effects of a permitted agricultural activity differ in several significant ways from what is proposed. And in any case, as set out in 18, and it's for that reason that Ms. McGrath said in 10.18 of her section 42 report that the application of the permitted baseline is not particularly determinative in this case, although she has applied one. So moving now to the status of the forest remnants under the National Policy Statement for Indigenous Biodiversity. The applicant has submitted that the forest remnants do not meet the definition of significant natural area under the NPSIB. Ms. McGrath, on the other hand, considers that they do. This impacts, of course, the provisions of the implementation provisions and policies of the NPSIB that are triggered by this application. The NPSIB has a two-part definition of significant natural area, and I've set out the second and relevant limb of that definition at 5.2. In terms of how that definition is met by plans and policy statements that were in place when that policy statement commenced, we note that both the Westland District Plan and the West Coast Regional Policy Statement were both adopted before the commencement of the NPSIB. And while the Westland District Plan does not map specific SNAs, it provides criteria for their identification and allows those areas to be identified through a resource consent process. The West Coast Regional Policy Statement also adopts an approach of identification via criteria at resource consent stage. Mr. Payne considers that the two forest fragments meet the relevant criteria. It's submitted that the areas identified through the application of these provisions does meet the second limb, notwithstanding the fact that the MPSIB also requires that that area be subsequently mapped where it is identified through a resource consent process. If the panel does not accept that the forest remnants meet the threshold of already identified for the purposes of the MPSIB, we do submit in the alternative that the MPSIB still imposes requirements on significant Indigenous biodiversity outside of these areas. Specifically, 3.16.1 requires that significant adverse effects of new uses on Indigenous biodiversity outside SNAs must be managed in accordance with the effects management hierarchy. It is Mr. Payne's evidence that the Indigenous biodiversity effects of clearing these forest remnants will be significant, and that the effects management hierarchy has not been followed by the applicant's proposed conditions. And so those cover the four legal issues that we had identified through the course of the hearing, and essentially by way of summary set out at 6.2, we set out our submissions on those 4 points, and that is that while the activity at the core of the application is undoubtedly mining, it also includes elements of Indigenous vegetation clearance and industrial activities which are subject to discretionary rules. The Indigenous vegetation clearance and industrial activities overlap with the mining to such an extent that the proposal should should be bundled and considered as discretionary overall. It's accepted that Rule 7 within the SASM chapter does not have immediate legal effect and is not a trigger for consent at this time. And the permitted baseline must include a non-fanciful permitted activity. In this case, it appears that an agricultural activity has been proposed. This must not only comply with permitted standards, but also be realistic on the site. The appropriate comparison is what might sensibly be anticipated, and this is relevant to nighttime activities, built form, and potentially boundary treatment as well, and which you might expect from a permitted agricultural activity on this specific site. An appropriate and non-fanciful activity has not been specifically set out, and the evidence of the relevant experts indicates that the proposal will have effects outside what you might normally anticipate. In terms of the forest fragments, it's submitted that these do meet the definition of the second part of the SNA definition set out in the NPSIB, but in any case, even if that's not accepted by the panel, the effects of the proposed Indigenous vegetation clearance, the evidence suggests the effects of that clearance are significant and that the effects management hierarchy is therefore required to be complied with. So that concludes our submissions if there are no questions arising.
I have a couple of questions.
Sure.
So MPSIB
Yes.
definition has two components, one of which is identified.
Mm-hmm.
Identified as a past participle. Are you saying that identified within the meaning of MPSIB could include areas that meet a criteria that a plan anticipates applying in the future in relation to a resource consent application?
I'm sorry, sir, could you repeat the question?
The word identified
Sorry.
is a past participle.
Yes.
Are you saying that a plan that sets criteria for the identification of an SNA in the future through resource consent applications falls into the category of being identified for the purpose of the plan?
Yes, that is our submission. We acknowledge that it is not the usual way of SNAs being identified in plans. Generally speaking, they are mapped as part of the plan making process. The two relevant, the district plan and regional policy statement in this particular instance haven't taken that approach. They have set out provisions for the identification and something of a piecemeal way through the application of criteria to resource consent applications. That's the approach that those two plans have taken to identification. We fully acknowledge and accept that it is an unusual approach and is certainly not as clear as the mapping approach that is more traditionally taken to SNAs.
And why do you say, in light of clause 2.5.3 of the plan at page 26, the plan is taking that approach when that provision says, we acknowledge we haven't identified them, but we intend to do so?
Apologies, you're looking at page 26 of the Westland District Plan.
Clause 2.5.3.
Yes, I think that our submission on that point would be that the approach that's been taken in the provisions in light of that interim, in light of 2.5.3 is something of a transitional identification through resource consent, application of criteria at resource consent stage, but fully acknowledge that it is certainly a less clear form of identification than mapping through the plan making process.
Well, it's saying, it's using the conventional understanding of identification in the second to last sentence, saying we acknowledge we haven't done it. How can that be ambiguous? It has included an interim measure, but it doesn't proclaim them to be identification.
I can address it. That's correct. The reason we're interpreting it the way we are, and as Ms. Butler-Ford says, it is a bit tenuous, is that it is clear that the district plan has strong objectives and policies to protect such vegetation. And yes, ideally, it should have mapped them, and most district plans do that. But in this case, it has identified criteria And the word identified, I think, in that 2.5.3 is difficult to interpret. But if you look at the plan in context, as you said on the first day of the hearing, that can be used to ensure that you actually get a interpretation of the provisions that comply with the Resource Management Act Part 2. But at the end of the day, whether you accept that the areas are SNAs under the NPSIB, there are still provisions in the NPSIB, I can't remember exactly which clause Ms. Butler-Ford referred to, that you'll need to consider in order to protect, is it protect, or 3.16.1, those areas must be managed by applying the effects management hierarchy. So that they need to be managed in some way, whether or not they are part of the district plan or they are significant in terms they are Indigenous biodiversity outside of SNAs under the NPSIB.
Yeah, no, we accept that significant Indigenous vegetation, both under, well, certainly under the district plan, requires consideration in terms of the objectives and policies of the plan. There's no dispute about that. What I'm struggling with is that you say the approach of the plan is to set criteria to identify them, and the second to last sentence of the passage of identified expressly contradicts that submission by saying, we acknowledge we haven't identified them. What we've done in the interim is simply provide some criteria to satisfy as far as we can on the information available, section 6B, but not going so far as to identify them. And if the plan says that, then how can I say that it meets the second definition of an SNA under the plan, both because of my past participle point, and secondly, because the plan expressly acknowledges it hasn't done that job?
In our view, what the plan says is that at the time of the district plan being notified, it has insufficient information to identify them. But if through a resource consent process, the areas are identified, then they need to be managed. So we read...
No, that's an incorrect use of the word identify. That is classified according to the criteria in a resource consent application. I'm talking about identification in a plan.
Yes, that's correct. The council hasn't identified them in the plan because at the time it had insufficient information to do that. Correct. So I think it's really clear, well, and the council submission is you have to read identify as being qualified by the council having insufficient information at that time. So they could not identify them specifically at that time because they didn't have sufficient information.
Well, whatever the reason, they didn't do it. They didn't identify them.
No, that's correct, which is why they set out criteria so that they could be identified at a later stage when the resource consent application was being considered and assessed.
So do you say that identification in a plan is done by assessment of criteria in a resource consent application?
Ideally, they should be mapped. And I think that's what is potentially one way of reading the NPSIB. And that certainly would make your job as a panel a lot easier if they were identified in a district plan and mapped.
Well, it's not a question of whether our job is easier or not. The question is whether it fits a definition.
Well, the council's position is that it does.
I struggle with that submission. The criteria that you refer to in the plan, where are they located?
or just try and find them, there they are.
Just refer me to the page.
It's page number 80.
80.
Yes, so this is the natural habitats and ecosystems provisions policies.
Right, so we're, oh, I see. This is the, okay, just give me a moment to read those. So, are these sorry, 1 to 8
Yes.
cumulative criteria?
Well, I think that the introductory wording in policy D says that it's habitat shall meet 1 or more.
Right. Okay, so you are saying that policy description sets up a criteria for SNAs
Yes.
or significant indigenous
Yes.
vegetation.
Yes, that is in our submission. This is the approach that the Westland District Plan has taken to identification of SNAs.
So do you read, and just looking at the methods there, do you read as if coming after E, or do you read F as being independent of E?
I read them as being separate.
Because what I'm trying to understand is is the method by which this policy will be implemented, will it require council to conduct that survey as an E, and then in considering resource consent applications, then recognise and provide for their protection? Or is it saying that we will, regardless of whether we've done E or not, we will recognise and provide for the protection in any resource consent application with Indigenous vegetation that meets the above criteria?
I think we would suggest that your latter characterisation is correct. That the council will make decisions on resource consents, notwithstanding whether E has happened or not, will apply F. We read each of the methods really in this section as operating quite separately. Noting that there is no reference or qualifier in F that refers to mapped or listed areas.
Sorry, I'll just bring up the submissions again to finish that point.
You have, yeah.
Okay, so turning away from the SNA point. If your submission is, no, still on that point. If your submission is that the SNAs are identified through the means of their policy criteria, which then loops you into MPSIB.
Yes.
Did you direct the council then to do the assessment under those policies?
No, sir, not as far as I'm aware.
You mean in relation
if identification works the way you describe it, doesn't it follow that you then have to tell the ecologist, you need to go through those criteria and satisfy yourselves it meets those criteria in order for it to be identified, in order for the IB to apply?
I think Mr. Payne can probably answer that. He did go through that criteria.
Yeah, but did you, so Mr. Payne, what was your conclusion on those criteria?
They meet those criteria.
They meet those criteria? So your evidence is that if I look at those criteria, just for a moment, I'm really lost in the documentation. So is it your evidence that all of the criteria are met?
The MPSIB, yes.
No, in the district plan.
The district plan,
Yes.
not all of the district plan criteria is met, no.
No.
But some
Which are?
distinctiveness and possibly the one that relates to threatening, but that's obviously still up for, needs further investigation to understand.
Right. But 3, distinctiveness,
Yes,
is an ecological district assessment, and you've said, no, I'm doing a narrower assessment. So how does that work?
I'll just open that up and so I can
Yeah.
explain it in detail for you.
Page 80 of the district plan.
Yeah. Let's read it out so it's just clear.
I'll just ask a question, Ms. Ford, as while Mr. Payne is doing that. Has council got examples of applying these criteria to other applications?
We don't have that information, but the council's planner might be able to answer that. We've only been instructed in relation to this application.
Yeah, okay, we'll ask who that.
So the criteria says the area has indigenous species or an association of indigenous species, which is unusual or rare in the ecological district, or endemic or reaches a distribution limit in the ecological district. The area may be distinctive because of the influences of factors such as altitude, water table, soil type, or geothermal activity. My assessment is that where these forests are, there is distinctive soil types there, sandy coastal environment, and that in this lowland area, forests here have been greatly reduced, over 90%. And so these are now rare in the ecological district, this lowland coastal mature forest.
Right. So you're saying that the distribution of forest of this type within that type of landform, the coastal environment, which has its own distinctive soil. Does that change the ecology in a meaningful way? What does it do?
Yeah, you get different plants growing in those types of environments. You also, you're going to look at the abiotic conditions. So it's a lot warmer down there, high humidity, higher influences from salinity from the coastal environment. And it's less prone to extreme weather. And so the way that animals and seasonally how these forests behave are different to the forests whether inland or at high altitude. It's what makes coastal forests really important for some species. And it's that association there that's different and where I make a distinct contrast to Dr. Keesing and Dr. Bramley, who I guess lumped it all together to say, hey, look, there's lots of forest in the ecological district. You look at it in the entire ecological district, very small fragment. What I'm saying is that these lowland coastal forests are very different to the inland forests.
Right.
And those at high altitude.
So are you saying it's quite unusual to find this type of forest just on private land or on part conservation reserve?
So my assessment has been focused on this ecological district and then looking at the geology and landform specific to rarity and distinctiveness there. Now, the reason I look at landform, and I'll come back to you, but I can answer your question if you like, directly. So directly on private land, it's very rare. There's very little left. There's about 250 hectares within a 3,500 hectare coastal environment, coastal band. And of that, 75% occurs within the Mahinapua Scenic Reserve. Remaining 25% are these clusters of relative to that ecological district, smaller fragments of forest. And Forest B is one of the larger representative samples of these patches of forest within that coastal environment.
I just ask a supplementary question along this coastal environment? So your figure 4, your addendum.
Yeah.
Can you just help me to understand?
Yeah.
Why you've drawn the inland boundary where you have?
Yeah. I've drawn it there based on where you can see a change in topography. There's a distinct change in topography and a distinct change in geology further inland from north. And so I've mapped that kilometre band where there's coastal influences within here, where there's a change in geology, and where it's that forest and those abiotic conditions are consistent through those areas there. And when there's a distinct change. And I used Barrel et al.'s paper initially. I looked at that and went, that's really interesting. We've got this distinct landform here, this as a basis to understand what was going on. I initially did it to understand whether the site was in the coastal environment or not. I decided that it wasn't in the coastal environment because the coastal environment, it wasn't a significant contribution to it, to these, but it is some. I mean, these are old sand dunes, these old sandy soils, so there is some, but it wasn't a significant enough contribution to meet the NZ coastal policy statement. So then my mapping varies just slightly to Barrel's there because I didn't include the lake itself. But for all intents and purposes, when you add the two figures together, very much the same. But I have used my professional judgment to map that line for sure, and I've put a lot of thought and emphasis into that to go, okay, well, where are we looking at here to ensure that we have like-for-like comparison of resources and not to skew things. Yeah.
So this location you're saying with coastal plain, it's from the true left of Whariwhare to the coast. What was that? I'm saying it's
no, not necessarily. It's where the sandy soils are. So from the river that
So you're saying before it's what? Can you just repeat the numbers you gave to me before in terms of the overall area that's remaining
within the coastal environment, within that particular about 200. I think it's 252 hectares I mapped. So roughly 250. You know, with the scale of your mapping that you do, there's obviously approximations around that.
And the remnant,
it's about 180 hectares of which are in the Mahinapua Scenic Reserve.
And the remnants, how much?
That leaves 7 hectares. This is in detail in my evidence. Focus on this and how I've broken it. Get to you. It's number 28. My evidence.
Yeah, we'll come back to you on that. Just want to pick up that point. So the bundling point I don't think there's any debate about that. The question is how, not so much how the restricted discretion might operate, but not that it matters a lot in this case, but when you're doing the evaluation, while bundling might make sense, you still have an eye to the policies that relate to the specific activities to which they apply. So bundling isn't an excuse to lose sight of the policy framework.
No, it's not. And so you would still obviously look at the policies that may have resulted in a restricted discretionary activity status being applied to mining, and then also, of course, the policies in in the various documents that are more protective of ecological values and landscape values, and then undertake an assessment of those policies together.
Yeah. And turning to the question of whether or not mining includes veg clearance.
Yes.
I'm just interested in your comment on this indication in the document, and I'll just pull it up. So first of all, the definition of vegetation clearance, somewhat in your favour, talks about veg clearance in a classical sense for any purpose.
Yes.
But then in relation to mining,
Yes.
the environmental outcomes from mining are the protection of significant indigenous vegetation. The objectives of the management of mining under the plan are the protection of significant indigenous vegetation only.
Apologies, which provision are you looking at there?
AEOs, anticipated environmental outcomes, Roman numeral 5.
Protection, yes, that's right.
So only that outcome is sought. And then if we look at the explanation and reasons for the mining provisions, it says in the first paragraph, sorry, the second to last paragraph of page 93, the third to last sentence, the large-scale earthworks associated with mining operations can make the establishment of indigenous vegetation difficult. I'm not quite sure what that means, but it seems to anticipate that mining will involve removal of indigenous vegetation. I mean, it's a funny sentence, but
it is.
It's trying to describe the type of adverse effects of mining that might be involved in, and is specifically referring to indigenous vegetation, and consistent with the AEO that I've described. The matters of discretion are limited to effects on significant indigenous vegetation, not just effects on indigenous vegetation generally. So there does seem to be a coherence. It's not easy to ascertain which of those positions is accurate, but there does seem to be some coherence in the argument that mining was intended to be evaluated as an intrinsically destructive activity that would impact on indigenous vegetation, of which really it's hard to find any part of the coastal plain that doesn't have parts of it there, but really to protect the significant indigenous vegetation. That's the thrust of the mining provisions. And that works under Mr. Lowe's would I describe, reframed assessment as much as it does Ms. McGrath's assessment. I mean, it seems to me, what additional value does applying a significant veg clearance rule add to the planning framework beyond just saying mining can destroy indigenous vegetation, but we will capture it in our matters of discretion and protect and the policy framework. What does it add to our task?
I suppose in this particular application, as we said, the matters of restricted discretion are broad, and so arguably it's more, the mining rule is more akin to a fully discretionary activity than the majority of restricted discretionary activities that you might find in other more recently drafted plans. But it's hard to know what difference it might make in another application, just in terms of the operation of the rules generally. And just in terms of the explanation and reasons for mineral resources, that sentence, I suppose we would say that in terms of the third that sentence that you identify, the large scale earthworks associated with mining operations, would in our view be limited to, you know, the earthworks of the extraction and the mining as the definition restricts the use of that term. So in terms of what it might add to your assessment, in light of the breadth of the matters of restricted discretion, from a practical point of view for this application, it might not add very much. But in our view, it is the way that the rules and definitions are intended to operate. Yeah.
Oh, I understand the rationale for it, and it's not easy, but
no, it's not. They are challenging rules, definitions, objectives, policies, and outcomes, to be fair.
But I just wanted to satisfy myself that before I get too conscientious or intense about it, to stand back and say, well, how does it really matter? Because the thrust of the plan is for us to protect significant areas, and you get to that route whether you follow the separate discretionary classification or the more narrow RD class.
Yes. And I think our view that in terms of the difference made in this particular application, our view that the difference is relatively small for your purposes does flow from Mr. Payne's evidence that the biodiversity at issue here is significant. So squarely falls within that matter of discretion either way, whichever approach you take.
Yeah. But even if it didn't, what was the discretion again?
Page 158, avoiding, remedying and mitigating potential adverse effects on significant indigenous vegetation and significant habitats of indigenous fauna.
Why would the plan? Yes, just
I've got a question.
Yeah.
Ms. Ford, I'm struggling to understand what mining activity could be undertaken without clearing without clearing vegetation. And so it seems to me that they've come up with a restricted discretionary rule, which, as you say, is extremely broad and clearly aimed at addressing it seems, most, if not all, aspects of mining.
Hmm.
Surely the clearance of vegetation would be assumed to be included within in that. And so the question is, what sort of mining could be conducted without clearing vegetation?
I suppose it depends on the state in which the land is when you come to it proposing to mine. And obviously not all sites will have extensive indigenous vegetation on them. So they might well be covered in some type of vegetation, as broadly as that term is defined and understood. But the real question for the purposes of the third point of the discretionary rule would be, is about indigenous vegetation. So many sites will obviously be covered in some sort of vegetation, but that doesn't necessarily mean that all sites would trigger the discretionary rule as we say this one does. It really turns on what they're covered with, what their vegetation cover is when you come to make your application. So the clearance of exotic vegetation, whether it's associated with exotic forestry or pasture cover or whatever that might be, that would not trigger the third bullet point of Rule C.
Okay, so you're saying clearance of exotic, it would be considered on that rule. Otherwise, anything indigenous is coming under a different rule.
Yes, and obviously if it meets that rule has its own intricacies, but obviously it's got its year and area restrictions and its exclusions, and the qualifiers about its connection with nearby features there at A, B, and C, the first A, B, and C.
Yeah, thank you.
Can you point me to the page where the policies for mining apply?
I can, it's 4.9. 4.9, which, no, mining, sorry, apologies. One direction or the other.
4.13, page 93.
Oh, thank you. Okay, all right, got that, thank you. I just wanted to check some point. So I think that we've done the mining classification issue extensively, so that covers off, I think, all the questions I have. Do you have any remaining questions?
Yeah, just one regarding the permitted baseline, and you reference in paragraph 4.5 of your legal submission that it would be fanciful to have an agricultural activity operating 24 hours a day, 7 days a week.
Yes.
I just want to explore that with you a little bit. Because I mean, obviously agricultural activities do operate 24 hours a day, 7 days a week. The animals are still there.
Yes.
And so what are you saying? Are you saying the sort of the effects may be in relation to mechanical noise or something like that?
Yes,
Is what they operating
yes,
24 hours a week, or are you saying that activity is high?
No, I fully appreciate that the cows are operating 24 hours a day, 7 days a week. But I think what we were intending to get at there was sort of the I think Mr. Lowe made reference to it in his original statement of evidence. Apologies, I don't have the exact reference to it, but he talked about mining sort of being comparable in terms of the use of heavy machinery on site. And what we were trying to get at in terms of that 4.8 is simply saying that yes, an agricultural activity might well use machinery that generates similar effects, but you wouldn't anticipate an agricultural activity to have that element of it operating at that level of intensity for 24 hours a day, 7 days a week. It's more, as we understand it, more cyclical in its generation of those sorts of effects, rather than a 24-hour operation of machinery.
Yeah.
Thanks for clarifying that.
I understand that point. And I think you're right that that it's not easy to just translate provisions that have their primary function to control permitted activities to an unusual activity like mining, where all effects are being considered. I think the primary argument about permitted baseline was originally quite narrow, which is if the concern is about the visual effects of the processing plant, then you could have strong enclosure by shelter belts and other activities that would be non-fensible, that would have similarly screen more distant views to the landscape. And that's probably an area where you could easily imagine in a non-fanciful sense an activity occurring, because you see its manifestation throughout the region, the district.
Yes.
But in relation to noise, for example, you're on more safe ground to say mining is to be assessed for its amenity effects. And a baseline may not be appropriate because the level of activity would not be 7 days a week up to the limit of the plan, but that in the policy framework, you would recognise that mining has to occur where the activity economically.
With the minerals are, yes.
Yeah, and that it's a rural production environment in which levels of amenity equivalent to residential areas is not anticipated.
Yes.
All right, that's clear.
Yeah.
Happy?
Yes.
Do we need a break?
Um,
Do you want a break or carry on?
I'm easy to carry on to 12, I think.
Yeah, all right, we'll carry on. So that takes us to Mr. Payne. Thank you very much, both of you, for those submissions. And I'm sure it's been a running dog for you to keep up with this process as things emerge and you get asked to respond to them. So I appreciate your efforts in that regard.
Thank you. I wonder if the commissioners, while I know that you were keen to hear from Mr. Payne, in terms of the council's experts, we wonder if it's if it would be more helpful to hear from Miss Leach first on noise. She's going to be very brief, and I understand that you will just be having a few questions for her. That would then flow on to Mr. Payne, and then whether or not Regional Council wants to follow Mr. Payne or let landscape and planning for the district council follow, we're in your hands in that regard.
So my answer to that question is, it's probably you're asking that, making that suggestion for efficiency purposes, which I agree with. And while I acknowledge that both of the councils are having different reporting planners, not least of which regional planning is substantially different from district planning, my view is that this is a combined case, and it's logical for the planners to follow all technical experts, even though some of them don't impact. So I don't see the two planners as presenting a different case, but part of a joint hearing for planning purposes, sorry, for hearing purposes. So my suggestion, and I'm happy to be corrected in terms of how you see this as being efficient, is to have Ms. Leach and Mr. Robertson first, then Mr. Payne, and then as between the two planners, whatever order they choose. Is that acceptable?
Our view is that there's probably an efficiency in hearing from Mr. Payne before Mr. Robertson, just because of the way in which their evidence is connected. And so it would make sense for their order to be reversed from what you're suggesting. But then in terms of the overall order that you're suggesting, that sounds more than sensible.
All right, well, I'm glad that's the case at this hour of the day. What I suggest then is, just as we'll follow that suggestion, we'll go Mr. Payne and then Mr. Robertson. Just as a matter of warning, if you want to change your mind, Mr. Payne will be required for quite a long time. So
Understood.
for Mr. Robertson to sit here and listen to that, then that's what you're in for. Okay.
Yes, that's fine. Thank you.
Thank you. So we'll get Ms. Leach on.
Good morning.
Good morning. Welcome.
Thank you. So I'm Lindsay Leach. I've been reviewing acoustics on behalf of Westland District Council. So I've been through Mr. John Farron's evidence, and one of the main things that has changed, he is now predicting much lower noise levels from a revised schedule of equipment, and the duration of daytime works is also reduced, so it now finishes at 7 p.m, so it's just a 12-hour daytime shift. So the result of that is there are now minimal exceedances predicted. It's only up to 2 dB above the nighttime noise limits, and only for a very brief period. So essentially I am in agreement with him that the existing noise environment will mask that, and I don't see that that causes adverse effects for surrounding residents. So I've had input into the recommended conditions, and I'm suggesting slightly different wording to that the applicant has recommended. The applicant wanted a blanket 55 dB LAQ between 7 AM and 10 PM, whereas I prefer the wording that references the operational district plan noise limits and provides an exception up to 47 dB. So essentially what Mr. Farron predicts, but not allowing 55 dB up till 10 PM on every day. So I believe that's come through in the latest set of conditions. For truck noise, I'm essentially in agreement with Mr. Farron that
From whom did this amended condition come from?
I believe the latest version is from Melissa McGrath. I might be wrong.
Is that the version called amended conditions combining Ms. Clark and Ms. McGrath's combined inputs, or is it a separate document again?
Sorry, logistically, we were unable to combine this weekend, so happy to take that away as homework.
Okay.
So
we don't have that yet.
Right, my apologies.
Yeah. So just explain that to me again. Where's the area of difference between you and Mr. Farron?
So the requested condition from the applicant wanted noise limits for daytime defined as 7 a.m. to 10 p.m. So that the actual noise limits don't change. It's 55 dB LAEQ 15 minutes during the day, 45 dB LAEQ 15 minutes, and 75 dB LAF max during the night time. It's just the times during which those apply. So the applicant has requested daytime 7 a.m. to 10 p.m, nighttime conversely 10 p.m. to 7 a.m. And I would prefer that the times in the operational district plan apply. So that's Monday to Friday, 7 a.m. to 9 p.m, Saturdays 7 a.m. to 6 p.m. For the daytime limit. All other times, including public holidays, 45 dB LAEQ 15 minutes. And then the nighttime, all days, 10 p.m. to 7 a.m, you've got the additional 75 Lmax limit. And then additionally to that, the 4 dwellings that Mr. Farron predicted would exceed the 45 dB nighttime limit, just allowing what he has predicted. So relative to the operational district plan, that's just between 7 a.m. and 7 p.m. on Sundays and public holidays. So it's allowing what is predicted. It's not allowing a blanket 55 dB up till 10 p.m. every day.
And what's the difference between 47 predicted and 55 between the hours of 7 p.m. and 10 p.m?
So this is where I have a slight difference of opinion with Mr. Farron. He states in his evidence that the levels of up to 55 dB are likely to be masked by the ambient noise, and having looked at his data, I believe it will not be masked to the same extent that he is claiming. And I believe that.
And what are the masking sources?
So what was measured and stated in Mr. Farron's evidence was a pretty much constant level of surf noise, which will reflect in the L90, so the level which is exceeded 90% of the time, and then passing traffic, which affects the average noise level. So in his evidence, you see that difference between the constant base level of surf noise and the intermittent traffic noise, which is at a higher level.
So the noise environment that these residents currently experience is one with a significant background ambient noise from the coast. Is that correct?
Yes. Yep.
Punctuated by the impact of traffic on the state highway.
Yes.
And in those conditions, what's the difference in health effect between setting a 55 dBA to 10 PM as opposed to 7 PM?
So in terms of residents' amenity, if you're allowing 55
No, I'll come
dB
to amenity, but I'm talking about health effects.
health effects, you would see a certain level of annoyance. So the WHO defines 55 dB as the onset of is that moderate annoyance? I think that's right.
So it onsets annoyance after 55 and before 55 it doesn't?
There are categories, so between 50 and 55, and another category of 55, over 55, sorry. And it's to do with annoyance, and I can't remember the exact wording.
So what's the annoyance for 50 to 55? What do they describe that as?
I think that is moderate annoyance.
Moderate annoyance? And is that based on a percentage of population that respond in that way?
Essentially, yes. So it's got to be taken at a population level. So individuals will vary. Some people are more sensitive, some people are less sensitive. So yes, it's done at a population level.
Would we describe people who choose to live in this environment as self-selected for non-noise sensitivity?
I would not normally categorize people in that way. I guess it's possible, but it's not normal practice to categorize people in that way. The other factor in this is the high level of background noise that I believe if you were living in a rural environment with a very low level of background noise, and then you had a noise source coming into that area, then you would be looking at high levels of annoyance. But in this case, you have a relatively high level of existing noise, which I agree with Mr. Farran, that will mask most of the site noise for most of the time. So I don't believe there will be high levels of annoyance in this situation.
And that's only for 4 receptors, which is not a population level response.
No, it's only those 4 receivers on Sundays where it's 2 dB above the permitted level. And in general, you would say that a difference of 3 dB is just perceptible. So your average person will not be able to tell the difference between a noise level that is 2 dB higher.
Thank you. Right, truck noise.
Truck noise, I'm happy with Mr. Farran's approach. There is some increase to nighttime trucks, but it's still a low level of truck movements. The main thing from nighttime truck movements will be the potential for awakening, which is usually connected with the LA max. So you just got that noise event as a truck passes by. So there is a slightly increased potential for awakening effects, but there is heavy vehicles going past at the moment. So that's an average of 4 heavy vehicles per hour currently, and then on average that will double, an increase of another 4 heavy vehicle movements per hour overnight.
What's the average distance from the state highway of these residences?
I couldn't tell you off the top of my head, but I mean, there's a lot of dwellings along the transport route. I think I read it was about 47 kilometres. So the closest ones, it's approximately 15-20 meters.
Yeah, it's just the house I'm staying in is about 30 meters from the state highway, and I can't hear anything at night. That worries me. Is that a difference in attenuation potentially, or?
It will, traffic noise will decrease as you get further from the road. It will also depend on the construction of the building, how good the glazing is, whether you're actually facing the road or facing away from it, whether the windows are open or shut. So there are a number of factors to consider.
Yeah, okay, that's fine.
So you recommend a number of controls to be incorporated in the management plan. What are they?
That is essentially driver education. So the applicant's suggested condition for the noise management plan had training of staff relating to how to minimize noise and vibration. And I would like to change that, well, add to that, to say including drivers accessing the site on a regular basis. And that should include not educating drivers not to use engine braking, which is known to annoy residents, and just driving in a careful manner so you're not sort of clanking trucks unnecessarily. The other recommended measure is in that noise management condition, just having a maintenance schedule for the site access road surfaces. So if a pothole appears, because if a truck drives over it, then anything loose in that truck will clank around and make unnecessary noise.
Okay, thank you.
Is that all, or you want to treat anything else?
So I did have a section in my response to Mr. Ferran's evidence on wetland noise, just to note that he has predicted there may be some effect on bitterns calling within 150 meters of mining activity, but I will defer to the ecology expert to assess the effects of that, just to draw attention to it. And the only other thing I wanted to cover was noise monitoring. So the applicant's suggested condition has compliance monitoring within 30 days of, I believe it's the wet concentrator plant starting up. So that's essentially checking when operations start that levels are similar to what has been predicted. I would like to add to that that when works are coming up to those dwellings in the northwest corner, compliance monitoring should also be done at that point, because I believe that's year 10 when it gets up to that corner. So, you know, that's a long way down the line just to check that things are still at a similar level and manageable for those residents. So just as a one-off exercise.
Yeah.
And that, yeah, that's all I had.
All right.
Just a couple of questions. Are there any special audible characteristics of the noise from this site that will, you know, make noise worse or lessen that noise? For instance, when we're on site yesterday, we noted that it's like a sand pit. So a lot of the excavators are not running around on rock or digging into rock. So there's not that sort of banging, clanking that you'd normally get at a quarry.
Yep. So that's something that's quite difficult to predict. But the standard that's used for compliance monitoring, so that's NZS 6802, that allows for special audible characteristics. So that's that covers tonality, so anything that's got a whine or a hum, impulsivity. So when the compliance monitoring is undertaken, there are some objective ways of measuring these special audible characteristics, but the first test is just a subjective opinion of the person doing the noise monitoring, who should have, you know, a reasonable level of experience in these things. And if an SAC is detected, then there is a penalty applied to the site noise. So if you were measuring the site noise at, say, 45 dB, and it had a significant amount of clanking or a whine or, you know, something that stands out, then you would apply the 5 dB penalty to that. So the rating level would be 50 dB, and that rating level you assess against the noise limits. And that allows for, you know, the annoyance factor from those sorts of characteristics.
And I'm just wondering, is that something that, you know, a qualified noise expert should be making a decision on when we're talking about special audible characteristics, or is it something that could be applied by a sort of a trained member of the staff?
Potentially. So the usual requirement for noise monitoring is a suitably qualified and experienced person. So somebody from site who's just been handed a noise monitor and told to stand there and press go would not be suitably qualified. But if they have had some training and yeah, some experience as well in noise monitoring, then potentially, yes, somebody from site could do that sort of noise monitoring. I would expect in this situation, because it's a one-off, it would be more sensible to ask a noise consultant to come along and do that. Like if it was ongoing monitoring, then you might well want to get somebody from site trained up and, you know, go and stand outside once a month and check noise levels. But this would be a one-off at the beginning of site operations, and then again when works are coming up to those dwellings in the northwest corner. So I would anticipate there would be a noise consultant.
Okay, thank you. Last question. You might have to remind me what happens when there's a complaint received in relation to noise, and answering this. The question is, would it be appropriate to increase the requirement for noise monitoring after a complaint is received or a non-compliance detected?
So the noise management plan will have a complaints management process in it. That is a fairly standard thing, and noise monitoring in response to a reasonable complaint might well be a requirement. I don't anticipate that would be enough of an issue to include that in the conditions. I would have no objection if it was in there, but I don't believe it needs to be. But yes, that would be a fairly standard requirement in a noise management plan.
So can you remind me what the how often the noise has to be monitored as the conditions stand at the moment?
So a one-off noise monitoring within 30 days of the, I think it's the wet concentrator plant commencing, and then again during year 10 when works are approaching the dwellings in the northwest corner.
Okay, and so if there was a complaint received after the year 10 monitoring, there'd be no additional monitoring to check whether it's complying or not?
There's no provision for that, but given the size of the site and how far works are from dwellings, it's going to be completely inaudible for a lot of the time. But yes, potentially that could be in the conditions to say additional noise monitoring in response to a reasonable complaint.
Well, I suppose what I want to know is whether you are recommending it or not, based on the likelihood of a complaint being received and then no follow-up monitoring.
I think the likelihood of noise complaints is low. Noise monitoring in response to a reasonable complaint is a fairly standard provision in a noise management plan. I don't believe it needs to be in there, but it wouldn't hurt to have it in there.
Okay, thank you.
Very good. Thank you, Ms. Leach.
Thank you.
She's gone. Out of here.
I know she's speaking.
I'll be back. I was just going to say thank you for remaining there and available while we went through quite a lengthy process with the lawyers.
All good.
But we've spared you the ecological. Thank you. All right, so that brings us to 12 o'clock, which is lunchtime. Is that what's scheduled? So we're going to have 45 minutes and then return, and then we'll deal with ecology.
So if I can clarify, I have circulated track change provisions that reflect the district council changes, including ecological recommendations from Mr. Payne. So they were circulated this morning. We have not merged the two.
Right, let me just check that I've got that.
That you should have received that this morning, just in case there is a need to
Yeah.
refer to them whilst discussing matters, particularly with Mr. Payne, and imagine.
Yeah.
If not, I can recirculate now.
So, were they attached to your,
They were circulated as a, so it should be labelled section 42A, attachment 1, recommended.
I have that, thank you.
And I have tracked change Mr. Lowe's latest
Yeah,
version.
good. Thank you.
I keep track of all the versioning. But yes, I do apologise for, I was unable to get Ms. Clark's changes.
No, that's fine, that's fine. As long as we're all, Ms. Clark, did you amend the latest version as well? Yeah. All right, well, that's makes life easier. All right, well, we'll resume at 12:50.